So, hello everyone and welcome. On behalf of RIKK, Institute for Gender Equality and Difference, and the Gender Equality Studies and Training Programs at the University of Iceland, I want to welcome you, both those sitting here in the hall and those watching the live stream or recording. So welcome to the future, or the past. Today's lecture is the fourth in the RIKK and GRÓ-GEST lecture series, Queer Iceland in an International Context, in spring 2022, and is titled Mobilizing for Intersex Rights in Iceland. My name is Daniel, and I'm the Executive Director of Samtökin 78, the national queer organization of Iceland. And for the last 5 years, we have put intersex issues, alongside many other matters, as a priority in our advocacy work. And therefore, I'm extremely happy to be here with you and hosting this event today. Today's lecturer is Daniela Alaattinoğlu, an Icelandic Research Fund postdoctoral researcher at the Faculty of Law here at the University of Iceland. Her current research project investigates the mobilization for intersex rights in the Nordic countries. Before I give the floor to Daniela, I want to mention that after the lecture, we will have time for questions from the audience. But without further ado, Daniela, welcome.
Thank you very much, Daniel, and thank you all for coming. Thanks to RIKK also for hosting this lecture series, and it's a pleasure and an honor to be part of it. So my name is Daniela Alaattinoğlu, and today I will talk about a part of my postdoctoral research project, namely the part that focuses on Iceland. So the title of today's talk is Mobilizing for Intersex Rights in Iceland. And the structure of today's talk is the following. So I will start by talking about the topic of intersex and the medical gaze. I will then move on to talk a bit about human rights as a tool to promote change and what that means. I will focus particularly on Iceland, but also take into consideration global events. I will then move on to the Icelandic Gender Autonomy Act, that was passed in 2019, and especially talk about an amendment from 2020. And I will then finally look a little bit on the limits of human rights and sort of the what I refer to as the blurry boundaries of medical necessity, so where sort of law and medicine meet each other, and what can be some challenges and problems there. But to start, I want to start by not providing perhaps a general definition, because there are very many definitions of the term intersex. In the Icelandic law that I will talk more specifically about in this presentation, the term intersex is not used, but people with variations in sex characteristics is the term that is used. The term used by many activists is intersex, and I am also using it because I am looking at particularly how people are mobilizing to change the law to protect intersex rights. And therefore, as I am looking at these actors that are bringing these claims forward, often then referring to themselves as intersex, this is also the term I have ended up using. But a sort of broad definition of what can we consider intersex in this sense? That really depends on how we define male and female, because intersex can be defined as people whose bodies, so whose sex characteristics, then that can be their anatomies, hormones, genetics, somehow fall outside or between what is socially considered as within these boundaries, this binary of men and women. What we often use is the term then sex characteristics, that then refers to the body of people then born with sex characteristics that fall outside of the binary or between, or how one like to define it. I should say, and I think that is very important to point out, that that does not say anything about how these people then, or how the group identifies what their gender identity is, because that actually most intersex people identify as male or female. So intersex in this sense is not, I'm not using it as a gender identity per se. So what is the sort of problem, or what is the challenge, the thing that is a human rights challenge when it comes to intersex people? So the main challenge is what is often referred to as normalizing surgeries. It should be said that not all intersex people do undergo some kind of medical interventions. Actually, some people that can qualify within this intersex definition might not even be aware of it. But importantly, in around the 1950s and 1960s and onwards, medical doctors have been conducting or starting to treat or doing some experiments on how to normalize the bodies of babies, especially, born that have sex characteristics that they do not then identify as clearly male or female. So this is a group of intersex people that have been and are still today targeted by these sort of, sometimes they're called normalizing surgeries within quotes, because it's sort of a way to make it look, to make their bodies look more as expected from society, so either male or female. Yes, these surgeries especially, they're also not just surgeries, but other forms of treatments as well. But especially the surgeries are referred to as IGMs by some intersex human rights defenders. That then is sort of an allegory to FGM, or female genital mutilation, so intersex genital mutilations, because the problem here is that often then intersex people as babies or newborns, before they can know what their gender identity will be in the future, how they will feel about their bodies, have these decisions taken for them by doctors, parents, that they cannot consent to, obviously because they are babies, and that are then impossible to reverse often, and might lead to, for example, these people becoming infertile, and is affecting their whole lives. So this is, I would say, the main area that intersex human rights defenders are mobilizing around, these surgeries. I have here one picture. It's from Pink News that took this picture in 2020 from an intersex human rights defenders manifestation, where you can see, I chose to include this picture here because I think it quite well shows the claims and what is important. So my body is not the problem, surgeries are, as you can see here, one slogan. So challenging this way of that society has of sort of identifying, or the need to identify everyone as male or female and to assign a gender, even if the bodies of children do not correspond to that. So by force then to, through surgery, sort of make them conform to it. So this is the problem that is often mobilized around. And there you can also see, I think quite well, the allegory again to female genital mutilations, because that is also, that also builds on sort of these cultural notions of how a woman's genitals should look like. And in intersex treatments, that is often a little bit similar also the case. So in my research, I should perhaps say that I am a lawyer. So I look particularly at sort of how these groups have used, and their allies have used human rights, especially, as a way to promote some kind of change, to institute laws to make these practices stop. And I use a theoretical tool that I call, or that's called Grievance Formation. So I'm particularly interested in not just how the groups are mobilizing, but also how this is, how the states are corresponding and how society is responding to this mobilization. And if society and the legal framework starts to understand these practices as rights violations, and how does that happen? So how does this go from a topic that is considered just medical, a medical problem, sort of the medical gaze again, an illness that has to be corrected by medicine. So from that to a human rights violation that the state has to take measures to stop this from happening. And perhaps also for the people who have undergone these kinds of treatments that are not medically necessary, but based on aesthetic or social, psychosocial concerns rather. What is the responsibility of the state towards these people? Because they continue to have problems from this, and this is also an important claim by intersex human rights defenders, that there should be compensations and remedies to the group, because if there has been a human rights violation, there should be some form of remedy. So I am looking at sort of this process to see, focusing then on the Nordic countries. And I thought that it would be, I thought first that it was quite an interesting paradox, that the Nordic countries consider themselves to be sort of very human rights friendly, very gender equal, but that then actually at the moment Iceland is the only Nordic country that has prohibited these kinds of interventions. And there is quite, when it comes to intersex rights, the Nordic countries, apart from Iceland, is not particularly on the forefront of human rights at all. But rather this is perhaps a topic that's not really taken up on the political agenda. It's considered to be a small group and not really as a political priority. I'm looking at how intersex rights organizations have started to mobilize. That is, I think, something very important in order to understand how this topic has become one of human rights. So from just being medical experiments, medical treatments, to actually intersex rights organizations being founded. This happens particularly in the 90s, 2000s. We have ISNA is founded in the 90s, and then OII in the 2000s. So these two important organizations of people, so intersex activists are starting then in the 90s and 2000s to gather and challenge these practices and challenge this sort of medical gaze and medical understanding of the intersex body as something that has to be medically corrected. That should be said, of course, some intersex conditions can be life-threatening and can require medical treatment, but I am not really referring to these here as such, but we're talking about the medically unnecessary treatments and interventions. So in the 2010s, so relatively recently, some supranational or international human rights institutions within the United Nations, within the Council of Europe, start to pick up on this topic and understand that, okay, so there is some kind of problem here, that this is happening in many, many countries, and also countries that like to call themselves on the forefront, developed countries, on the forefront of human rights. We have this systematic non-consensual medically unnecessary surgeries taking place. So we have, for example, the Fundamental Rights Agency is one of the early institutions to pick up on this and problematize it in a report from 2015. We also have the Council of Europe Commissioner for Human Rights problematizing the topic. There is, since the 2010s until today, we also have the European Parliament that has recently also issued recommendations that condemn these interventions, and that actually say that states, EU states, should introduce legal bans. So it should actually be prohibited. And some countries have introduced bans. This is mainly thanks to intersex human rights defenders that have been mobilizing actively in these countries. Iceland is one since 2020, but Malta was the first country in 2015. And then we have Portugal, 2018. These are then European countries. Then there are other examples also in the world, like Uruguay has some kind of a ban, and then also some Indian states, for example. But we don't have so many states yet. Another state that can be also mentioned is Germany, that actually just last year introduced a ban also on these interventions. These bans are a little bit different from each other, so it is quite difficult to say something about them in general, because some of them have, for example, penalties for doctors that transgress the ban. Some don't. And some of the bans are criticized for not being implemented at all in practice. So even though a country has a law that looks very good, it does not, unfortunately, necessarily mean that it is actually being implemented and followed in the country. I will now look at Iceland in particular. So some important, I think, events taking place during the 2010s in Iceland to raise awareness of the topic is perhaps most importantly that Intersex Iceland is founded in 2014. And really, with its founder also, Kitty Anderson, stepping out in public, sharing stories. And this is picked up a bit by national media and also social media promotion of the issue. So there is some kind of awareness raising of the problem and problematizing that this is also taking place in Iceland, that there are intersex people also in this small country, and these interventions that are not medically necessary and non-consensual are actually taking place here. Then 2015, so just a year after, the Ombudsman for Children released a statement. So that is then the first Icelandic state institution that picked up on the topic, released a statement against these interventions, and said that they have to stop, and also refers to this as a human rights violation, and says that this is potentially unconstitutional, also against the Icelandic, a violation of the Icelandic constitution. But also a violation of other human rights, such as the rights of children in the Convention on the Rights of the Child. And this is also an important event. Then we have a government program in 2017 that promises to make lives of LGBTI people sort of more durable or better. And I think this is something that has been also used a bit in the activism. This promise by the government to actually put some political priority onto the matter. And then in 2019, there is an important Amnesty International report that problematized these practices. Interviewed doctors, for example, saying that this, showing sort of evidence that this is happening in Iceland, it is a human rights violation, and this is clearly an alarming topic. And of course, Amnesty International is an actor that generally gets involved in the most serious human rights violations, so this is also something that is quite heavy. And that should be said throughout this period, so during the 2010s, activists, also together with some politicians, have also organized and not just raising awareness, but actually drafting law, so drafting a similar or an original version of what today is then the Gender Autonomy Act, that I will talk a little bit more about. So I have chosen to include this quote by Kitty Anderson in an interview with Amnesty International in this presentation, because I think it shows quite well. So this is from 2016. So when this when the mobilization had been going on for some time. So you can see that there is it is raised as a human rights issue. So here said that it said that our goal is to end all medically unnecessary interventions on children that are based on cosmetic or social grounds. So again, you can see cosmetic social grounds. We also need to educate people and raise awareness to overcome stigma, as well as provide more psychological support for parents, so that intersex children do not feel isolated or alone and can get easy access to support and peer networks. So actually many requirements there. We need to move towards a psychosocial framework which accepts intersex people, because the problem isn't with intersex kids. It's with society expecting them to conform to their ideals. It doesn't matter if it's an intersex kid or not. All of our children deserve to grow up in a world where their human rights are respected. And I think this is a good quote also to show how human rights rhetoric and human rights as a tool was used in order to show that this is not something new. It is not something sort of extreme to want. It's about basic human rights. And it's not just about the rights of intersex people, but it's actually about how society views male, female, and what it does to people that do not conform to these ideals. So I think it's a very good example of how human rights were used. Then we come to the Icelandic Gender Autonomy Act. This was a law that was passed in 2019. It was a progressive law in many ways, but it focused on legal gender recognition, and it introduced so-called third gender. It also changed the legal gender recognition procedures and rules surrounding it. A so-called third gender because there is now also the possibility to have an X as a gender identifier. That is important, mainly for non-binary people, and legal gender recognition also, of course, very important for trans people. Also during this period, sex characteristics, which is then a special category or a special ground that then refers to intersex people, was introduced as a protected ground in national discrimination legislation. The problem when the Gender Autonomy Act was introduced in 2019 was that it postponed. So there was a plan to introduce a ban on intersex interventions that are not medically necessary and non-consensual. An original plan, it was in the original drafting, but then because of different political disagreements and disagreements between the medical profession and the people also promoting this law, there was a postponement. So it was not included in the law that was passed. But the government then appointed a working group that would then particularly look into this question of intersex interventions and how to regulate them. And then in 2020, there was an amendment finally that introduced a general ban, but I will talk a bit more about it. So, I think that this is sort of the most important points when it comes to the 2020 amendment. So these points are all regulated especially in Article 11A, if you want to have a look at the Icelandic Gender Autonomy Act. It regulates that permanent changes should always be in line with the child's wishes and best interest. So the best interest of the child, and of course the child's wishes if the child is old enough to express that. But you can see clearly that the child's best interest and children's rights are at the forefront of this amendment. There is a duty for hospitals to, or the hospital that deals with the matter, to provide counseling for parents and the child in line with age and maturity. It is also obligatory that a second opinion, or the possibility to get a second opinion, should be offered, and that should also be free of charge. So that means then that that parents and the child can get a second opinion from a medical professional that is not in the team that deals with intersex children, so from outside the team. It also stipulates, the amendment, that if it is possible to postpone treatments, that is something that should be done. And then, of course, ideally to an age when the child themselves can understand the intervention and can also consent or form an opinion on the matter. There is a general ban of medically unnecessary and non-consensual permanent changes. But there are some exceptions to this ban. And I think that was perhaps also something that when I'm researching, also doing some interviews, and something I've talked to many of the people in this committee that then drafted the 2020 amendment. Something that was perhaps the most discussed matter were actually these exceptions. So there is a general ban, but there are two exceptions. One is hypospadias, in cases of hypospadias, and the other one is micropenis. And these are two situations when the penis does not fulfill the sort of function, or does not look according to what medical science says it should do. So these were two exceptions that were introduced, but they are to be revised within 3 years from the date that the amendment was introduced. So by 2023, there should be a revision whether it is a good idea to have these exceptions, or whether this exception should be taken away from the law. So, of course, quite little time has gone since then. There is, importantly, in the law, a right to truth, which means that, because for many intersex people, I think also globally, there's a problem that these the interventions that have been done on intersex people have many times been kept from them, and they might have a problem accessing their own medical records. So the Gender Autonomy Act is actually addressing this, and says that the patients themselves, or the people themselves, should always be able to access their medical files. And the counseling and what has been said in the counseling should be included, and what has been done should be included in the medical records. So there should be quite detailed information. And there is also an obligation of parents to inform kids that have undergone some kind of interventions, to inform them about them as they grow older. Very importantly, there is also a reporting duty. So hospitals have to report then to the state or the Directorate of Health about how many surgeries and interventions, what kind of interventions are being done, how many, so that statistics can also be kept on the topic. And that is something that is actually now regarded as something that is called a best practice when it comes to human rights. It's something that the Icelandic law does very well, and that intersex human rights defenders in other countries are pointing to this as a good example, because it has this reporting duty, mainly of hospitals. Yes. When we then come to the final slide of the presentation before your questions, I refer to this as sort of limits of human rights and the blurry boundaries of medical necessity, and sort of where can one draw the line? What is medically necessary? When is something just based on medical reasons? When is something based on social aesthetic reasons? I think that is also interesting in the Icelandic example, because there are these, you can see that there is a general ban, but then there are these exceptions when the law clearly says that this is not strictly based on medical grounds, but or it is actually based on social, psychosocial, aesthetic grounds. But we consider them to be sort of important exceptions. There is, in general, when it comes to human rights and intersex, a lack of binding legal obligations. So legally, that is a problem. So everything we have is internationally is referred to as soft law mainly, which means that important institutions, human rights institutions, have taken a stand. But these are policy recommendations, so they cannot really, no country is really obliged to, in a legal sense, to, for example, introduce a ban. There is no case yet, for example, from the European Court of Human Rights. There is one pending case, so we will see how that turns out. But in general, human rights as tools here comes to this problem as it is mainly sort of recommendations. So something good if countries do, but if they don't, then, well, it is always quite difficult here also to draw the line between strict medical necessity and social, psychosocial, and aesthetic reasons, also because doctors are, of course, also people acting in society and are informed by social norms and rules about how men's and women's bodies should look like. And I think that there is a good, this is taken from the Intersex Society of North America, ISNA, and they have this a scale that they refer to here as the Phallometer. So when drawing the line, when a newborn baby is born, so if the clitoris is sort of if it's small enough, then that can be considered a girl. Or then, is it a penis? Then it should be big enough. as you can see there. Then you see it's okay, it's a boy. And then there is a certain measure where they measure that when it's sort of something that medical science does not accept as sort of unacceptable. It's not, small enough, not big enough, so there should be a surgery. And this is, of course, I mean, it's a bit also as it's an effective campaign tool, but also something that should be taken or viewed in its context. But of course, based on this real evidence that this is how genitals have been sort of defined, and it is, of course, when you think about something as complex as gender identity or how people will feel about their bodies in the future, then of course measuring it like this, and that this is something that then determines somebody's future is of course quite problematic. And then quite classic, the best interest of the child is also at the forefront of both of the intersex human rights defenders, but from a certain point of view also by the medical professionals, because it is also something that is being said that, or being considered as something that children, when they grow up, will want to be. It is in their best interest to have sort of genitals that, or bodies that conform to what society expects. So the best interest of the child is sort of a blurry concept that very much depends on the person speaking, and everyone sort of is acting, at least officially, with their best intentions. But then, of course, that is something that can affect people for the rest of their lives. So I thank you very much for your attention. I've used up all my time. So I look forward to questions, comments. Thank you.
Is it done? Yes. Thank you very much, Daniela, for this. Any questions here now in the audience? Yes, we have a question. Okay. Please just state your name before the question, and your horoscope sign, and your favorite color.
Okay. Hi. My voice is like loud enough. Okay, so thank you for presentation. I would have two questions. The first one, I'm interested, you were mentioning at the previous part about the framework. So I'm wondering if we are dealing with this topic, is the human rights or like gender studies framework, queer studies framework, where we should put it in order to contextualize in the best way? And the second question is related to the idea of, in principle, of the best interest of the child. And I have a background in law, and I never figured it out in which way we could evaluate or understand freedom to make decision of children, because I'm familiar only with the concepts in civic law, where children are allowed to like receive gift, and in that way we can allow the decision of child. But in these like important topics where parents still have a crucial role and they can really influence what is the will and the decision of the child, how can we be sure that the voice of the child is really included, especially considering that children are rarely asked about these things and only grown people are deciding about the children. Yeah. Thank you.
Thank you. Should I answer now, or do we collect questions?
I think you should just answer this question right now.
Yes.
And hopefully we have some time for more questions.
Yes. So excellent questions. I think, of course, when it comes to your first question, whether this is a human rights question, a gender studies question, of course it can be both. I mean, this is something that you can understand from a strictly human rights point of view, and something that then is sort of, is it a human rights violation? What should the legal remedies be? What is the obligation of the state? These kinds of questions. And then also from a gender studies, and perhaps also gender and law, which is also a discipline that I also do myself. We can perhaps more think about it from a more critical point of view also, the sort of how is gender constructed in the law and in this field, also in medicine, and perhaps also with a more critical perspective and a more a perspective that is based on gender sensitive theory, then perhaps one can also question these social rules on what is a man and what is a woman, perhaps a bit more deeply than one can merely with human rights, I think. And the second question, I mean, that is, of course, the classical question when it comes to the best interest of the child and the wishes of the child in general. And it's not just something that we see when it comes to intersex children, but also with many questions when it comes to children's really capacity also to consent. And perhaps the problem is not only in that children are not adults, but perhaps the problem is also how we construct consent and how the legal system is placing so much, really so much importance on the topic, and perhaps also qualifying some situations as consent that are not in the sort of wishes of the person in question. But I think it's a classical question, and I think when it comes to intersex, the as I think as I said also, the best interest of the child can of course be at the background of not doing an intervention, but also doing an intervention, because one can think that, oh, but the child will want an intervention when they are grown-ups, or you can think that they will not want one. So this is of course a very blurry concept, and perhaps the problem is also a bit in how it is sort of legally constructed. I hope that not really answers your question. I don't know if your question can get an answer, but yeah, I hope it corresponds to your question at least.
Thank you very much. There's another question here.
Hi, I'm Salma. My question is maybe similar to Nicola's question. It is inspired by, we had a visit from some back in 78 or 87, 78.
78.
Yeah. So we were speaking about intersex persons, and they told us that intersex activists are advocating for intersex children not being forced or not having surgery until they are able to speak and decide for themselves. Now, putting aside the problem of maturity, is just pure ability to speak sufficient to say that a person is making a choice or can make a choice? I was wondering if the fact that any age or any stage in person's development should be considered as a point where the decision is made, because if we ask a person, what do you want this or that, we are somehow implying that a choice must be made. So how to avoid this pressure of for intersex person to choose when they could just issue of surgery, we are actually reinforcing these binaries on intersex persons, and I believe they should just stay as they are if they want. So, I don't know if it's clear.
Thank you very much.
Yes, thank you. Thank you very much. I think that is also a good comment and a question, and I think it also relates, as you said, to the previous question, because it also, as you say, if you also ask somebody throughout their development, so now do you want the surgery or not? Now do you want the surgery or not? It is sort of reinforcing at some point there should be a surgery. And of course, in the Icelandic law, I think that is good that said that when possible, interventions should be postponed. So as long as it's not medically necessary, meaning then threatening to their health or their lives. And perhaps that is also, as I said, relating to it, because it's in a way this sort of, we put so much weight on this saying yes or saying no as just consenting. So if you say yes, then it's consent, and no, it's not consent, without looking at the general context of under which circumstances are you consenting. And of course, it's a kind of a coercive circumstance in the first place that we have very binary societies, and you are born with a body that do not correspond to that. And of course, there is there's sort of an implicit coercion in that. And that's something I think that also the law is not really able to respond to, unfortunately, at least at the moment. It would be, it would take more than just a simple amendment to change that in the law. It would need to change something in the way we think, I think, and the way lawyers think. And yeah. Thank you.
We have time for a couple of more questions. Is there any in the audience? If not, I want to ask one, actually. Oh, we're raising hands. Could you tell me a little bit more about the civil case that is going on in the Human Rights Court right now?
Right. So this is a case, it's RIKK contre France. So it's a French case by an intersex person, but it is not really focusing on these interventions as such, but it is focusing on allowing for a third gender. And of course that should be said, but then, of course, bringing this kind of a case before the European Court of Human Rights would be a possibility also for the court to state something about this, which is something that they do at times, and also rule on the matter. But of course, it is also, in a sense, this case is a little bit. Because this is an intersex person that then identifies as non-binary. And that is, of course, not the case with all intersex people. And the French courts and the French state is saying that, no, we will not have a third option. We will only have male and female because it will just be too complicated otherwise. So the court is now due to rule on this, like, should states provide a third option or not? There is a risk that if the court would say that yes, there should be a third option for intersex people. So then saying that there should be like a third option which is restricted to a small group and not necessarily at all what the majority of this group would want. So it's in that sense it's a bit of a complicated case, but it also allows for the court to give statements on third gender as a category, as legal gender recognition more broadly beyond the binary, on intersex interventions, possibly, And in that sense, I think it is an important case. But of course, it would be also good if one case that specifically questioned the interventions would come before the court.
Thank you very much. We have a question here. Right.
Thank you. I just wanted to ask about Malta. I think you said it was like the first country to have bans on intersex surgeries. So how far are they in their implementation, I guess? Or like what's the picture over there like if they were the first to have this kind of law?
Yes, thank you for your question. So the Maltese ban has been hailed as a best practice example, also because it was the first, and it's like the Icelandic one, also has sort of roots in grassroots movements driven by intersex human rights defenders themselves. The Maltese ban has been critiqued a bit because it might be quite easy to sort of circumvent it, and for parents who wish that their child undergoes some kind of intervention to just take the child to another country. So in this sense that it's not that it's easy to go around and find a way around the ban as such. But the ban is as such has been hailed, and also introduced sanctions with it for transgressing medical professionals. Yes.
Thank you. I think we can squeeze one more question, just a short question. Is someone very interested in something? Okay. I think. Okay. Yeah. Just very, very short. We have 4 minutes.
Yes, just something we were talking about. We are not sure. For example, when we say LGBTI and all the rest letters and symbols, so we can make this distinction between sexualities, gender identities, and maybe sex identities. Where would intersex fall? It's not a question of sexuality. Is it a question of gender? What do you think? Or not quite?
So the specific term used is sex characteristics, and legally I think that is also a good question, because if you do not have sex characteristics as such protected, for example in discrimination law, there is a risk that intersex people are not protected by grounds of gender or gender identity, because it's not really any of them, but the specific term that would be is then sex characteristics rather than gender identity or gender expression. Yeah, I hope that answers your question. Yeah.
Thank you very much. Give it up for Daniela.
Thank you.
Thank you. Just going to wrap something up. Yes. Okay. Thank you all very much for the lecture, and thank you, Daniela. And thanks all for being with us here today. A lot of people here in the audience, and of course you at home who are maybe listening from your computer or watching this in the future. I would like to take this opportunity to invite all of you to our next lecture on March the 17th, when Guðrún Elsa Bragadóttir will give a talk about queer femininity in Icelandic cinema. But further information on the series can be found on the RIKK and GEST websites, rikk.hi.is and gest.org, that is GEST.org. But thank you very much. Have a nice one. Thank you.